So, Miss Adams, in the matter of the people of the state of Michigan versus Darius Lamar Bailey, file number 20-20067FH, I do not have in the file a probation violation summons. Unless,
Okay, I'll turn it, Judge.
okay, so why don't you just have a seat and we'll be right with you, okay? So, Miss Underwood, oh, so I have Mr. Ladd and I have Mr. Jones. Miss Underwood, would you like a breakout room with Mr. Jones first? Because he's been here since like 8 o'clock.
Yes, I would. Thank you, Your Honor.
You're welcome. So, Mr. Jones, I am going to put you in a breakout room with Miss Underwood. And there you go. All right, go ahead and join that breakout room. Mr. Ladd, who's your attorney?
I'm Mr. Ladd.
Okay. All right, so where'd he go? Oh, sir, I'll be with you in just a second. Mr. Bailey, come back up. All right. So, Mr. Bailey, I have a request and summons for probation violation. And it was filed by Miss Holly. It states that you violated the terms of your probation by failing to pay a court-ordered cost of restitution, currently owing a total of $13,653.34, restitution being $12,965.34. You've been on probation 4 years now? Sound about right?
Sound about right.
Okay, and that on December 21st of 2021, you got arrested for driving with license suspended. And you got some warrants for failure to appear out of those. It looks like Oakland and maybe Wayne County, right?
Yes, ma'am.
Okay, so so Mr. Bailey, I don't have anything in the file at all since 2021. And I know that you posted bond in the amount of 2,500, but I don't, Miss Holly is not here, but are you able to make any payments on your restitution?
Yes.
How much are you able to pay?
I've been paying every month. I can make 100 today.
Yeah, speak up for me.
I can make 100 today, but I've been paying every month.
Okay, you've been paying every month?
Yes.
Okay, and you're working?
Yes, ma'am.
Okay, so why don't you go down to the clerk's office and make that $100 payment for me?
Okay.
And then come on back, all right?
All right.
Okay. All right, the gentleman in the front row with the tie, what's your name?
Nicholas Schmidt.
Mr. Schmidt, okay. All right, so Mr. Ladd, I'm gonna take you next.
Okay.
Want to take Mr. Ladd next?
Yeah.
Okay. So, Mr. Ladd, I always try to take the people incarcerated first. All right, this is in the matter of the people of the state of Michigan versus Johnny Allen Ladd. We have two files, 23-21539FH and 23-21540FH. I have Salvatore Milaro appearing on behalf of Mr. Ladd and Isaac Sneed appearing on behalf of the people. So Mr. Ladd is appearing via Zoom from the Michigan Department of Corrections. So Mr. Milaro, how do you wish to proceed today on behalf of Mr. Ladd? And I have a note in my file that says we don't have fingerprints. Like we can't have much more of a captive audience than Mr. Ladd right now. So Miss Adams, can we let people know Mr. Ladd's incarcerated to get those fingerprints? So what would you like to do, Mr. Milaro?
So Judge, we'd like to set the oldest case for trial.
Okay. So let me get it. Okay. Miss Adams, you can either bring me the book or you can give me a trial date. So the oldest file is home invasion, 2nd degree, firearms, assault with a dangerous weapon, felony firearm. So how many days are you thinking you'll need for trial?
Probably 2 days, Judge.
2 days? Does that include jury deliberations?
Yes, I would say so.
All right, thank you. You want? All right. So that will be file number 23-21539. Who's your prosecutor on this file?
I think it's Mr. Sneed.
Mr.
Your Honor,
Sneed?
and the people would actually request to try the other case first. It's a simpler set of facts. It may help resolve the earlier case. That's file ending 40FH.
But we prefer the older file first, Judge, because it's the oldest file.
Okay, I typically go by the oldest file unless the parties agree otherwise, but Mr. Malaro is not agreeing with that, so, all right. So today's. And let's see. Mr. Ladd, when are you eligible for parole?
I think he's on the
I just
fly,
got a
Judge.
flop. They're flopping me out for 5 years. I'm already doing 5 years. So right now,
Okay.
as it said, I'm doing 5 right now. They're not gonna parole me on these charges I'm on. They just think I should max out. So I got
Okay.
16 months to 6 years to do.
Okay, I just wanted to check. All right, so I am looking at. I am looking at. No. So, Mr. Malaro, I'm looking at, no, I can't do that. Tuesday, November 19th at 9 a.m.
I can do that, Judge.
Mr. Steen?
Yes, thanks, Judge.
All right, so November 19th of 24 at 9 a.m. Wednesday will obviously be a 10:30 a.m. start date. So November 19th, I'm going to require that I'm going to set a final pretrial for November 6th at 8:30 in the morning on both files. And let's see, November 6th. I'm going to require that jury instructions and voir dire questions be provided to the court on October 30th. And motion deadline will be November 6th.
That's a hear or file, Judge.
Heard,
To hear the motion?
yeah, heard and filed. Because that's the last pretrial date. I don't have plea agreement deadlines, so. All right, so we are set for trial on November 19th at 9 a.m. I have a final pretrial as well as a filed and heard by motion deadline for November 6th of 24 at 8:30 a.m. Voir dire questions at voir dire, however you want to say it. Jury instructions are due October 30th of 2024. Is there anything else we need to address on the record?
Not this time, Judge.
All right.
And if we get a resolve, we'll call the court.
Obviously, if there is a resolution that is reached, if you want to bring him in as soon as possible, I will of course accommodate that. So anything else, Mr. Steen?
No, thank you.
Mr. Ladd, are you all set?
Can I talk to my attorney?
So he's in person, and so
Okay.
he can't really do that right now, but he
Well,
will
I just wanted to
schedule
see if he would
time.
send me papers,
You want your
send me
paperwork, like,
Yep, I'll get it.
my court dates.
Yep.
Okay.
yep, he said he will send that to you. All
I'll
Thank
Zoom
you.
with you, Mr. Ladd. Don't worry. Or come see you or whatever.
right, thank you, Mr. Ladd, where are
All
you
right.
right now?
I'm at Parnell Correctional Facility.
Okay, so you're close by. All right, thanks, Mr. Ladd. You have a good day.
Yes, thank you guys. Have a blessed day.
You too. All right, so. I'm going to bring back my other MDOC, Mr. Jones. Mr. Bailey, did you pay?
Yes, ma'am.
Come on up. So, Mr. Bailey, also on this, you do have a right to have an attorney represent you on this and other subsequent cases. Do you understand that?
Yes,
Now, you don't live in Monterey County, is that right?
that's correct.
So I can get a court-appointed attorney for you this morning, but I have to finish my docket. So are you able to hang out for a little bit?
Yes,
All right, so it'll probably be an hour or so before I can get someone to come talk to you. So, you know, you can go get breakfast across the street, go smoke, whatever you need to do, but just be back here by like 10:30 for me, all right?
okay,
All right, thank you.
thank you.
So Ms. Underwood, when we finish your dockets here and there, you can come see Mr. Bailey. All right. So I've got Mr. Jones back. Let me get Mr. Jones's file. This is in the matter of the people of the state of Michigan versus Jonathan Jones, file number 24-21842FH. Ron Underwood appearing on behalf of Mr. Jones, and I have Alexander Bayonetto appearing on behalf of the people. Mr. Murphy, I know that you have your client, and Mr. Noe is here as well, but I try to move my MDOC cases faster because I lose their windows. So, Ms. Underwood, how would you like to proceed today on behalf of Mr. Jones? This is date time set for pretrial.
Thank you, Your Honor. We have received our forensic back as to criminal responsibility. At this time, Your Honor, Mr. Jones wishes to accept the offer of the prosecution and plead guilty to count one, assault of a prison employee with no supplements, Your Honor. And we would ask the court for a HIDA to the low end of the guidelines on this case, Your Honor.
Okay, this is arraignment, so do you waive the reading of the felony information?
Yes, we do.
Okay, I did receive on August 4th, well, I received beginning of August, a criminal responsibility letter stating that they do not have the report done on criminal responsibility. But I do see back in June, the forensic examination was done. And was that done in district court? They put the order on the record?
Your Honor, I have the report dated August 7th.
If the court doesn't have it, Your Honor, I can forward it right now.
I have a competency to stand trial report in my file that was timestamped June 10th in district court. So there was another competency report, or is that a private one, Ms. Underwood, or?
No, this is a criminal responsibility report.
All right, I do not have the criminal responsibility report. It doesn't become part of the file. The last thing I had was an August 2nd letter saying we're working on it. But at this point, Mr. Jones is going to avail himself of the plea offer, right?
Correct.
All right. So,
With the COBs to the low end of the guidelines, Your Honor.
okay. So I'm copying to the low end of the guidelines, is what you're telling me?
I'm asking.
Okay. Usually you just tell me. All right.
I asked.
Okay. So Mr. Jones, you want to raise your right hand? Thank you. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Can you state your full name for the record for me?
Jonathan Jones.
All right. So Mr. Jones, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention then to plead, let's see here, you said plead guilty to count one. So is it your intention to plead guilty to count one, assault of a prison employee, which carries a maximum penalty of up to 5 years in prison and or a $2,500 fine with the agreement that you would be sentenced to whatever the low end of the guidelines are. Is that your intention?
Yes, will I be able to plead no contest though?
Is it no contest, Ms. Underwood, or not?
We
or
hadn't
no?
discussed no contest, Your Honor.
Mr. Banetto, do you have any preference? Does it matter to
Your Honor,
you?
as long as, nope, as long as there's a basis for it, I have no objection.
Okay, and so Ms. Underwood, with Mr. Jones, you're requesting a no contest because of lack of memory, right?
Yes.
Ms. Underwood, good. Any objection to that, Ms. Underwood?
No, Your Honor.
All right, so is it your intention to plead no contest to count 1 assault of a prison employee?
Yes.
All right, are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes.
Now, you understand the maximum penalty could be up to 5 years in prison, but there's a COBS agreement to the low end of the guidelines. Do you understand that?
Yes.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court other than the COBS to the low end of the guidelines. Is that correct, Ms. Underwood?
That's correct, Your Honor.
And Mr. Banetto?
That's correct, Your Honor.
And is that correct as far as you're aware, Mr. Jones?
Yes.
All right. Now I'm going to go through your rights with you, Mr. Jones. If a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you might have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
And Ms. Underwood, are you reviewing the police report for the factual basis?
Yes, I am, Your Honor.
Thank you. And if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Jones?
No.
All right, and so you want to plead no contest, you're going to have to say no contest to my next question, or not guilty, okay? So how do you wish to plead to the charge that on or about January 3rd of 2024 in Madison Township in the county of Lenawee, which would be where Gus Harrison is, prison, that you did commit the offense of assault of a prison employee? No contest or not guilty?
No contest.
All right. Has anybody made any threats or promises to you to induce you to plead no contest to this charge?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Ms. Underwood?
No, Your Honor.
Mr. Banetto?
No, Your Honor.
Other than your attorney saying she's going to ask for COBS to the low end of the guidelines, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
All right. Is it your own choice to plead no contest?
Yes.
All right. Ms. Underwood, would you like to place a factual basis on the record?
Your Honor, it is apparent from the incident report prepared by the state police Monroe Post on Thursday, January 18th, 2024, that on or about January 3rd, 2024, Mr. Jones was a prisoner lawfully incarcerated at the Gus Harrison facility in Madison Township, County of Lenawee, State of Michigan. At that date and time, Mr. Jones struck Corrections Officer Thomas Marr in the head, Your Honor, without Mr. Marr's permission, and obviously without his permission. We believe that constitutes the assault created in this matter, Your Honor.
Mr. Bayonetto, would you concur?
I would, Your Honor.
Based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on January 3rd of 2024, at the Gus Harrison facility where the defendant was lawfully incarcerated, located in Madison Township in the County of Lenawee, that the defendant did commit the offense of assault of a prison employee by striking a correction officer, an employment or an employee of the Gus Harrison facility, Thomas Marr, in the head while he was serving a term of imprisonment, and the court will accept the no contest plea. Has the court complied with MCR 6.2 or 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
And Mr. Bayonetto?
It has, Your Honor.
As I said, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in interest of either of them other than the Cobb's agreement. I'm going to refer this matter to the Michigan Department of Corrections for a pre-sentence investigation. And so Mr. Jones, somebody from the Michigan Department of Corrections Probation Department is going to reach out to you to do a pre-sentence report. So they're going to ask you questions about your background. They'll get some of the information from your prior PSIs. You pled no contest, so you do not have to make a statement about the events that occurred. Do you understand that?
Yes.
And where are you currently located?
Marquette Branch Prison.
All right. Great, Marquette. So, Mr. Jones, do you want to appear for sentencing via Zoom or in person?
Zoom.
All right, so we'll set that via Zoom. Mr. Stevenson, do you want to chat with Mr. Jones, or is that all the information you need?
I just need his MDOC number.
His MDOC number. Can we have your MDOC number, please?
619-879.
All right. Now, Mr. Bayonetto, there is no supplemental information on this felony information, and I'm assuming he does have a prior felony, or we wouldn't be up in Marquette prison. But if there were, those would be dismissed as well, correct?
Correct, Your Honor.
All right. Is there anything else?
Never mind. Okay. Nothing
All
else,
right,
Your Honor.
All right. So, Mr. Jones, we'll see you back on that day. Okay. Thank you.
Judge
Your Honor, I
said
tried to
sentencing.
send the,
What is
Sorry.
that date again, Your Honor?
September 27th at 8:15. What were you going to say, Mr. Bandetto?
Your Honor, I tried to send the criminal responsibility to Ms. Adams. It's saying our file's too large, so I will bring a copy of that up to your office today.
There should be a copy across the hall somewhere that the Forensic Center would have sent to me, I hope. So, but I appreciate you sending that up in her office mail.
Okay, no problem.
Mr. Jones, you're all set. Thank you.
All right.
All right. So, Mr. Malaro.
Daniel Simmons.
Yes. I have Mr. Simmons. All right, Mr. Simmons, if you want to unmute your device and start your video. He's been here since like 8 o'clock. I think he probably fell asleep. He showed up earlier than he needed to be here. Mr. Simmons, can you unmute your device?
Yes.
There you go. Okay, great. This is in the matter of the people of the state of Michigan versus Emmanuel Carlos Simmons, file number 24-21830FH. I have Salvatore Malaro appearing on behalf of Mr. Simmons. Mr. Simmons is appearing via Zoom. And I have Isaac Sneed appearing on behalf of the people. So, Mr. Malaro, how do you wish to proceed today with Mr. Simmons?
Judge, can I ask you to adjourn this one final time? We're close to having this matter resolved. There are some pending matters downstairs.
September 25?
Yeah, that's fine.
All right, so Mr. Simmons, I'm going to set this over for another pretrial on September 25 at 8:30 in the morning. Same Zoom number, so you just zoom into the same place. So September 25 at 8:30 in the morning. Mr. Malaro will do the stip in order to adjourn. Mr. Sneed, can you sign your name with permission?
Yes, Judge, thanks.
All right, so thank you, Mr. Simmons. You have a good day.
Thank you, Judge.
Who else do you have?
That should be it.
Okay, sorry. Mr. Murphy or Miss Underwood. Hold on, Miss Underwood's chatting me. I'm just gonna come over. Blah, blah. Miss Underwood. Okay, so, and I have not, I'll call Mr. Ott, Miss Underwood, but I don't have
I saw
MDOC.
him. I thought I saw him on the screen.
No, that was Johnny Ladd.
The MDOC bald gentleman. So,
That was Johnny Ladd. I have not
okay.
had a Mr. Ott. I'm gonna call it and we can just adjourn it. Get it off my stack. So in the matter of the people of the state of Michigan versus Jeffrey Travis Ott, file number 24-21860FH. I have Rhonda Underwood. He's in prison, you said? Yeah, he is. I have Rhonda Underwood. I had Mr. Malaro representing him, but I have Rhonda Underwood appearing on behalf of Mr. Ott. And I have Isaac Sneed appearing on behalf of the people. Mr. Ott is currently incarcerated with the Michigan Department of Corrections. Mr. Sneed, do you know if we had a writ done for today?
Your Honor, I don't believe a writ was done. He waived arraignment, so this would have been the first pretrial conference. So no.
Okay, so Ms. Underwood, I need at least a couple of weeks to get a writ processed and get him here. So I'm going to adjourn this to September 18 at 8:30 in the morning. And Mr. Sneed, your office can prepare the stip in order to adjourn to that day. And Ms. Underwood, can you sign your name with permission?
He can, Your Honor.
All right, very good. And hopefully we can get Mr. Ott back. All right. Okay, so I have Mr. Malaro set. Mr. Murphy has Mr. Lofton with you?
Yes, Your Honor. I know Mr. Schmidt's in the courtroom as well if you want to handle that case.
Mr. Schmidt, you want to come on up? I like when I get a bunch of pleas, but it does slow down. All right. So in the matter of the people of the state of Michigan versus Nicholas Thomas Schmidt, file number 23-21502FH. Mr. Schmidt is present in the courtroom. Mr. Murphy is appearing via Zoom, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. So, Mr. Murphy, how would you
Your
like
Honor,
to proceed?
there's a plea agreement in this matter that I believe Mr. Schmidt wishes to take, from my understanding. Mr. Sneed is offering for Mr. Schmidt to take a no contest plea based upon lack of memory to an aggravated DV, a 1-year misdemeanor under 769-4A. From my understanding, Mr. Schmidt does wish to accept that offer at this time.
All right, so Mr. Sneed, the plea offer is for Mr. Schmidt to plead guilty or to plead no contest to an aggravated domestic violence under 769.4A. I don't get those very often up there. So because mostly these are done in district court. So what is the relevance of that? 769.4A?
It's deferred under that statute.
Okay. Thought so. Okay, and Mr. Murphy, are you gonna place a factual basis on the record?
I will, Your Honor. We'll stipulate based upon what was at the preliminary examination.
All right, Mr. Sneed, is that a correct recitation of the plea?
Yes, it is, Your Honor.
All right, want to raise your right hand? And Miss Adams, I'll need a sentencing notice for this 27th for him in the courtroom. All right, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your
All
Honor.
right, can you state your full name for the record?
Nicholas Thomas Schmidt.
Okay, very good. So, sir, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest to an aggravated domestic violence, which carries a maximum penalty of up to 1 year in jail under MCL 769.4A, which is a deferred statute?
Yes.
Okay, are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, Your Honor.
And you understand there's no agreement regarding sentencing, correct, Mr. Murphy, other than the deferral?
Well, I thought there'd be no jail, just probation because of the deferral.
Is that correct, Mr. Sneed?
Well, we have no position on that, Your Honor, but I believe that the victim may appear at sentencing and address the court.
I don't think the deferral bars me from jail time if I so chose.
It's my understanding as well.
Mr. Schmidt, do you still want to go forward with it?
It's not saying you're gonna get jail. You may not. You might get deferred jail term, but there's no agreement regarding that. You understand that?
I understand that, but the way the evidence that you guys have.
Okay, I'm not gonna
So
talk about
don't-
the evidence because you have an attorney. So you have two choices. You can enter a plea or you can go to trial. So
Do you wanna-
if
Do you want to talk to
wanna
me?
talk further with
Yes,
Mr.
I'd like
Murphy?
to talk to Matt Murphy.
All right, so he's like 2 blocks over. Do you want to
Yes,
head
I
over to
know.
his office? Okay, so I'll set this to the side and Mr. Schmidt's gonna head over to your office, Mr. Murphy.
Okay, I'll bring in Mr. Lofton.
Okay, thank you. So go ahead and go on over there.
Thank you, ma'am.
You're
Thank you.
welcome. Mr. Dagger Margosian. He's still here. Oh, I lost Mr. Dagger Margosian. Okay. All right, so I don't have the attorney from Ms. Stenwell still, so. All right, Mr. Glazier.
Yes, Your Honor.
All right, so. Rhonda? Okay, all right, so I'll get Rhonda for you next, okay? All right, Mr. Murphy, do you have Mr. Lofton?
Your Honor, against my assistant's advice, Mr. Lofton left to go get breakfast, so I have.
You know what? I don't blame him. I'm hungry too.
We were
so-
going to ask to set the trial to a pre-trial. I don't know if we can do that without him, because he's been here since 8 o'clock. So
I know he has, but so 30 other people, so such as it is. All right, in the matter of the people of the state of Michigan versus Rodriguez Lofton, file number 24-21769FH. This matter is set for jury trial on September 5th of 2024 at 9 a.m. So, Mr. Murphy, what I'm going to do is, this was the final pretrial. Do we have parties already filed a lot of your questions and jury instructions?
Your Honor, I have neglected to do that. I do apologize to the court. I was going to ask the court. I'd spoken with Mr. Lofton yesterday and then this morning, and then spoken with Ms. Wagner over text messages. I think that I was going to ask, and Ms. Wagner would ask for the court to entertain taking the trial off the books and putting it as another pretrial. Mr. Lofton was asking for that as well, because there's some issues. We think we've come to a resolution on this case, but there's some probation issues he was trying to get resolved this week. We also, I don't believe this case has been pending for a very long time, so it's not an issue of length here for us again. So we're asking the court to consider that. Again, Mr. Lofton, I don't believe he's a flight risk pending no for adjourned for the trial.
No, he's not a flight risk. Well, I mean, kinda, because he gets R and O's all the time, but, it's a Thursday. I can set him for pretrial on. All right, Miss Wagner, I can take the trial date off. But I'm gonna set it for a pretrial on September 11. Would that be all right?
Yes, that's fine, Judge. Thank you.
Okay, so Mr. Murphy, I will take the trial date off. And then I will set a pretrial for September 11th at 8:30 in the morning, and you'll do the stip in order. Can you do an order removing, setting aside the trial date and also setting a pretrial for that day?
Yes, Your Honor.
And Ms. Wagner, can he sign your name with permission? We're not getting audio. Did you get a new laptop too, between you and Mr. Malaro? We don't get audio.
I did.
Is that fine with you?
It's fixed though. Can you hear me now, Judge?
Yeah, it just, I don't know. Yeah,
I
barely.
thought my audio issue was fixed, but yes, it's fine that he signed my name. Thank you.
All right, trial for 9/5 removed. Okay, all right. So thank you, Mr. Murphy. Rhonda Underwood, I have Mr. Canablo. So I want to come on up. So that's fine. This is in the matter of the people of the state of Michigan versus Javon Joshua Canablo, file number 24-21868FH. He's here today in person. I have Rhonda Underwood appearing on behalf of him. This is the date and time set for pretrial, and I have Alexander Bayonetto appearing on behalf of the people. So, Miss Underwood, how would you like to proceed?
Your Honor, I believe we're close to a resolution in this matter, Mr. Canablo. But I would like to be there in person. So can we just set this for one more quick pretrial?
I can, Miss Underwood. I also have a pickup that's here in person, so you're gonna have to wander over anyway. Do you want me to set him to the end of call?
We can do that.
Can you hang around a little bit?
Your Honor,
About another, you gotta go to work.
I got a tell that time from my girlfriend. She just had surgery on her
Okay.
on her ovaries.
We can set it for another day, Miss Underwood.
Thank you.
So how about, Miss Adams, can I get a notice of hearing from Mr. Canablo for September 18th at 8:30?
And can I ask you something about my bond condition, Your Honor?
So Miss Underwood, Mr. Canablo wants to address his bond conditions. Go ahead.
I was just wondering if we could like put them down or something like that, because I've been doing them every day, and without.
What are you supposed to do?
I blow 2 times a day.
Blowing 2 times a day.
Yeah, I blow 2 times a day. So I've been doing it with no hesitation and no problems and nothing like that. So
How long you been doing that?
I think I've been it for a month, I believe.
Just a month?
Yeah.
And you're here on a felony?
I'm on a concealed weapons charge. So I had my CPL.
Oh, hold on. So you're here on an operating while intoxicated second offense, carrying a weapon. Are you working?
Yeah.
Okay. What time do you go to work every day?
I go to work at like 8 in the morning.
Ms. Adams, is Mr. Coast here today?
I believe so. I thought I saw him earlier.
I reached the phone of All right, and where do you do them?
Mr. Coast
I
is
do 'em at
assisting
the-
with interviews
I
and
either,
juvenile.
Hold on, everybody's talking at the same time. Thank you, Miss Sierra. I just remembered that. You do them,
During the week, I come here at 11 o'clock, and then at nighttime and during the weekend, I go to the sheriff's office at 11 o'clock.
okay. So I'm gonna set them. What time do you go to work?
I go at 8.
Where do you work at?
I work for leaf and gutter guards
Okay.
in Ann Arbor.
All right, so I'm going to change this that you test 1 time a day, one time a day, early in the morning before you go to work. So you're gonna have to work with Mr. Coast on that, Darren.
I don't know who it is, so I don't know.
Okay, so I'm gonna change your bond conditions to require you test between 7:30.
I could ask my boss if I could come in a little bit later, so it's around like 10:30.
No, I'd like early is better.
Early as
Then I know if
possible.
you're drinking the night before.
Okay.
I'm assuming you're not like drinking, climbing ladders during leaf gutter stuff. So I'm gonna order, your bond conditions are gonna be that you have to do a PVT once a day between 7:30 and 9:30 every morning.
Okay.
Okay, and then Miss Adams, does he have to sign something?
Yes, Judge.
So have a seat at that table, and Miss Adams is gonna get you a notice of hearing, and also your bond conditions changed, and then, who are you, like, is there somebody you're calling to?
What you mean?
So you do the PBT here in the morning?
Yeah, I did a PVT.
You're gonna have to do it at the testing facility, and, Mr. Coast is, Miss McGreen, do we have any information back there on our testing facility in town?
Judge, I know Ms. Cannon has that information. I would suggest just reaching out to Mr. Coast.
Okay, so I'm gonna give you Darren Coast as our pretrial services coordinator. So I'm gonna give you his phone number, and you're gonna have to reach out to him. He's in a meeting right now. So you're gonna have to reach out with him to set up where you're gonna do that test. There's a
I'm
couple.
pretty sure they're gonna just send me to the sheriff department, because
Probably.
that's where the kiosk is.
But if you don't talk to him today, go to the sheriff's department before work tomorrow morning and do it, all right?
I'm gonna do it anyways, because
Good.
I don't want to get in trouble.
No. So, all right, so you're gonna get your paperwork, and now you only have to test once a day in the morning.
Okay, I appreciate you, Your Honor.
Okay, that'll help a little bit, all right. So we'll do the notice on that. All right, Ms. Underwood, we'll do the notice on that, Ms. Underwood, because he's here in person. So, Mr. Murphy, do we have, no, you were gonna talk to Schmidt, Brian Fry. Okay, anybody left that's a defendant in the courtroom? Rhonda, you have Miss Steinweitel? No, that's Michael Dagger McGowan. Okay, hold on.
We have Mr. Lerma.
I got a couple people with no IDs on their phones, so let's start with those. I'm running out of defendants here. Mr. Noe, you ready?
I'm ready.
Who's your client?
Mr. Eli,
Mr. Eli?
senior waiting room.
Is he not in jail?
No, it's not. It should be, I gave you
All right, I got a bunch of people logged in on devices with no names. So let's
Nice
see.
day, Your Honor.
You too, sir. Thank you. All right, so I'm sending someone on a Samsung device a note to, or chat to unmute. So could yes, what is your name?
Chad Ely.
Say it again.
Chad Ely.
Chad Ely. All right. I'm gonna change your screen name, so hold on. All right, I have another individual on a Samsung device that I sent a request to unmute. Can you unmute your device and tell me your name?
Shannon Heatherly.
Okay. Let me make sure I spell your name right. Rhonda, that's Miss Heatherly. Do you need a breakout room with her?
I don't think have I been appointed on it yet, Your Honor?
No, probably not. Hold on, Miss Heatherly. I'll be with you in just a minute, all right? All right, and there's somebody on a gallery. So I don't know who they are, so they're connected. All right, this is in the matter of the people of the state of Michigan versus Chad Matthew Ely. I have Charles Noe appearing on behalf of Mr. Ely. And I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for pretrial. So Mr. Noe, how would you like to proceed?
Your Honor, this matter, I think we'd like to get put on the trial calendar and have a final pretrial set as well.
Okay. So Mr. Ely is currently charged with criminal sexual conduct, 4th degree. Has there been a plea offer made in this file yet at all? Or?
There has been, yes.
Okay, can I, for the record, have it?
Thus far, Mr. Bayonetto has offered my client to plead guilty to a felony, well, I believe with no agreement on sentencing, or plead to a misdemeanor with a killabrew to 1 year.
So the felony plead as charged, or?
I don't know. I don't know.
So Mr. Bayonetto, can you put the plea agreement on the record, please?
Your Honor, we didn't really discuss exactly what the plea would be. It was some sort of felony charge with no jail, or some sort of misdemeanor charge with a killabrew to a year in jail. We never really nailed down exactly what those charges would be. And so that's kind of where we're at this point.
All right, so Mr. Ely is currently not in custody. So Mr. Noe, I am backed up on trials.
That's fully what I expected.
And
partially because of me.
Yeah, it's all your family law cases.
Partially, yes.
All right. No, I have some civil trials that go for a couple weeks at end.
You're not lying.
How many days do you think you need for a trial on this one?
I would hope so.
Is sufficient.
Yeah. I would agree.
So November 1, Mr. Noe? Mr. Noe. November.
No, I cannot do November 1. I'm
Is
sorry.
that because it's your birthday?
That's certainly one of the reasons.
Yeah. No, we're in November. So I'm looking at Tuesday, November. Wait, did I already set somebody for November 12th? I don't think so. November 12th?
I had a hearing in front of Judge Olsaver that morning. I really can't move.
Family Law Institute. Tuesday, November 19th.
I'm in a mediation that morning with Mr. Godfrey. I don't want to move that because I know I'll book up, keep booking into February at this point.
November 26th at 9 a.m.
I'm good with that.
Mr. Bayonetto?
That works for the people, Your Honor.
All right, so I will set a trial date of November 26th of 24 at 9 a.m. We'll set a final pre-trial date for November 13th at 8:30. Is that all right, Mr. Noe?
Just one moment, please. Yes.
All right, I'm going to make November 13 the motion deadline for all motions, including motions in limine, and then I'm going to require
What time is that? Is that 9?
Yes, sir. Oh, I'm going to require that all dear questions and plea or jury instructions be provided to the court by November 6th. Okay, it's a one-day trial. All right, is there anything else we need to address on the record with Mr. Ely?
Not that I'm aware of, Judge, no.
All right, we will get a copy of this out to the attorneys. And Mr. Ely, we will see you back on November 13th at 8:30 in the morning for a pretrial.
Yes, ma'am.
All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Do you have another client in the courtroom, or that's your,
That's it.
just your intern?
Yeah, that's right.
Okay.
None.
It's more organized.
Too long,
Your
I'll
Honor.
chat.
Okay, Mr. Ely, I'm gonna, yeah, he's gone. All right, Mr. Glazier.
Yeah, I have 2 cases. Could I do those? I have a Burke and our regional manager here to We have a
Okay,
meeting set up.
so Mr. Glazier, Maria Rodriguez. So in the
Yes.
matter of the people of the state of Michigan versus Maria Rebecca Rodriguez, file number 24-21897FH. Is Ms. Rodriguez present? I do not have Maria Rodriguez, Mr. Glazier.
She just called me. She was gonna get on.
Let's see, hold on. Let's see if she did. No. So then you have,
Jason Smith.
yep, is he in custody or no?
Last I knew he was, Your Honor.
Or he was in custody? Oh, let me call the Joe. Hi, this is Judge Ancelone. I have Zoom room 3 and 2 open, but I'm ready for Jason Smith and probably Andrew Sprague, but Jason Smith first.
You said who first?
Jason Smith.
Okay, okay.
All right, thank you.
Yep.
All right. All right, Mr. Murphy, you ready on Schmidt?
Yes, Your Honor.
Let me get his file.
You
All right, in the matter of the people of the state of Michigan versus Nicholas Thomas Schmidt, file number 23-21502FH. We are back on the record. Mr. Murphy, you've had a chance to speak with Mr. Schmidt.
Yes, Your Honor. He's right here in my office. I just didn't move the chair around. He does not wish to accept the offer, so we're going to continue the trial, which it's scheduled on September 4th, which is the same day as David Vickery, which is today as well for pretrial. So Mr. Schmidt's is the older file, so that's the one that's going to go on September 4th.
Okay, so Mr. Murphy, jury instructions and voir dire questions were due on August 7th. Have they been filed?
I don't usually do voir dire questions. I don't have any specific. I thought I had filed jury instructions a while ago. I'll double check, and if I'm incorrect on that, I'll refile them because it's just one count.
Okay. All right, and the motion deadline was today, so there's no motions. So trial is set for September 4th of 2024 at 10:30 a.m. I expect the parties to be present in the courtroom at least by 10 a.m. And the people, have they filed their jury instructions? And
Thought they had.
Yeah, I would have to double check the file. If not, we'll get those filed this week.
All right, and I would ask that counsel speak with each other and make sure they're in agreement on the jury instructions. Be here by 10 so that you can go back and review them, and we should be good to go. All right, so Mr. Schmidt, I don't know anything about your case. I only say this because I give fair warning. If there is a conviction, I do remand custody. So, all right, anything else, Mr. Murphy, on that case?
Nothing further to address from the defense, Your Honor. Thank you.
All right, if this case gets resolved or an agreement is reached, Mr. Murphy, please call me right away so I don't have a jury and we can proceed with your second trial, all right?
Yes, Your Honor.
All right, thank you very much. All right, I have a gentleman in a blue plaid shirt. What is your name, sir?
Dave Vickery with Mr. Murphy.
All right, Mr. Murphy, I got Mr. Vickery.
You will give me.
All right, this is in the matter of the people of the state of Michigan versus David Lee Vickery, file number 23-21617FH. I have Matthew Murphy appearing on behalf of Mr. Vickery and Amanda Wagner appearing on behalf of the people. This is the second scheduled trial on September 4. The plea offer in this case was plead no contest to an aggravated assault, receive 1 year probation, fines and costs, and no jail term. If he was convicted at trial, he'd be facing a maximum penalty of up to 4 years in prison, as well as a 2-year penalty on the felony firearm. So, Mr. Murphy, how do you wish to proceed today with Mr. Vickery?
Well, Your Honor, he is set for trial again on September 4th, and I mean, I can't prepare 2 trials on the same day. I'm preparing Mr. Schmidt's trial. I mean, I guess with Mr. Vickery's trial, well, the court hopes that we can come to a resolution on Mr. Schmidt's. Again, I'm not able to divide and prepare for both trials on the same day. I believe both trials are going to ultimately go. We've had discussions with Mr. Vickery on Mr. Vickery's case up until yesterday. And from my understanding, he wants to go to trial. He doesn't want to accept a plea. So I guess, I don't know if we can, again, I'm not going to be able to prepare for both Mr. Vickery and Mr. Schmidt's trial. Won't be prepared for him. So I guess if we could keep it on as a pretrial that day and go forward from there. Again, I don't think I'm doing service to both my clients preparing for both trials on that same day.
I can set it for trial October 3rd at 9 a.m.
Would that be okay with you, Ms. Wagner?
Yes, that's fine. Thank you.
All right, so we will adjourn the trial to October 3rd at 9 a.m. And Mr. Murphy, can you do the step in order to adjourn the trial from September 4th to October 3rd at 9 a.m.?
Yes, Your Honor.
All right, and we should have all jury instructions, what your questions, motions already being filed, so we should be all set on that. All right, we will see you back on, Mr. Vickery, we'll see you back on October 3rd at 9 a.m. Understand, I don't know anything about your case, but if you do get convicted that day, you will be remanded to the custody of the Sheriff's Department. That's my standard procedure on jury trials. So we are all set. Thank you, Mr. Vickery.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Mr. Vickery, I'll give you a call later the week, okay?
Thank you, Ms. Murphy.
Your
All
Honor,
right. Yes, Mr. Glazier. I got a
I have-
Samsung device that just popped in. It might be Miss Rodriguez.
no, she's not. She can't get on. I've got her on my speaker phone right now so she can hear us. I was going to
Okay,
ask.
so
if
in the
maybe-
matter of the people of the state of Michigan versus Maria Rebecca Rodriguez, file number 24-21897FH. I have John Glazier appearing on behalf of Miss Rodriguez, and I have Isaac Sneed appearing on behalf of the people. I have a lady on a Samsung. What is your name, please?
Shannon Heatherly.
Okay, just hang out for a minute. So
Brought me
Mr.
into the courtroom, I don't-
Mr. Glazier, how would you like to proceed with Miss Rodriguez?
Your Honor, what I'd like to do is adjourn it either a week or as quick as you can do it. And we'll do the next one by Zoom, but Miss Rodriguez is going to come into my office and we'll both do it by Zoom here at my office.
All right, I don't have anything available in a week or two. My next available is September 18th at 8:30 in the morning.
What date was that?
September 18th at 8:30 in the morning.
Miss Rodriguez, did you hear that date?
Well, Mr. Glazier, if you have her on speakerphone, it's an arraignment. Do you waive the reading of the felony
Yeah,
information?
we'd waive the reading of the felony information, ask for a pretrial, Your Honor.
And you're asking for me to enter a plea of not guilty on behalf of your client?
That's correct.
All right, and so September 18th at 8:30 in the morning, or do you want a pretrial farther out?
No, that's fine.
All right, so we'll do a pretrial September 18th at 8:30 in the morning, and my staff will do the notice of hearing because it's an arraignment day. All right, so.
Let me make sure,
that's
Miss Rodriguez, you got that date?
December 8th?
No, it's September 18th at 8:30. And you're gonna do it right here in my office. You're gonna come to my office and we're gonna do it by Zoom from my office. Do you understand that?
Yes, I do, Jen.
Yeah, and if you don't show up, they're gonna issue a warrant, so make sure you're here. All right, thank you.
And Mr. Glazier, I have your gentleman from the jail. So I have, are you Jason Smith?
Yes.
Okay, very good. So this is in the matter of the people of the state of Michigan versus Jason Lynn Smith II, file number 24-21863 FH. I have John Glazier appearing on behalf of Mr. Smith, and I have Isaac Sneed appearing on behalf of the people. I do have a letter dated July 2nd of 2024 from Darren Coast. It is a pre-trial assessment. Let's see, he was released from jail. It said Mr. Smith is facing 6 felonies involving a computer and possessing child sexual materials. Mr. Smith scored a 3 on the pre-trial assessment, which puts him at the low moderate end of failing to appear for court or reoffending. He does work full-time at Martin Rea. He was renting a room at the Adrian Inn prior to his arrest. His bond is $300,000. His parents are trying to get the 10% so they can go through a bail bondsman. Should he post bond, I feel it's appropriate. He have a GPS tether and no access to social media or computer, including a phone with computer capabilities. So Mr. Glazier, this is the date and time set for pretrial. How would you like to proceed on behalf of Mr. Smith?
I need to talk with Mr. Smith for a second, Your Honor.
All right, so Mr. Smith, first I'm going to change your screen name so I don't call you Mr. Palmer. So hold on.
I'll be there in just a second. Is Mike here yet?
All right, so I'm going to open up a breakout room, Mr. Glazier, with you and Mr. Smith. Okay. So I have a room full of people, but I don't have that attorney. Miss Underwood, let me see. I got Brian Fry. Brian, you're here on, didn't you, right?
I am here on Kelly Mahoney, Your Honor.
Kelly Mahoney?
Yes.
You want to call her, see if she wants to come in?
Your Honor, she's in the Jackson County Jail.
Good. So this is in the matter of the people of the state of Michigan versus Kelly Margaret Mahoney, file number 24-21862 FH. I have Brian Fry appearing on behalf of Miss Mahoney, and I have Isaac Sneed appearing on behalf of the people. So I don't know if we knew she was in the Jackson County Jail. So I apologize. She is not here. We can make arrangements with the Jackson County Jail to get her here. I sent notice, but that doesn't mean they present them. So I can adjourn this to another day.
Yes, Your Honor, we would request that. So, Your Honor, what happened is last time we were here, the court granted her a PR bond to attend Dawn Farms rehab, and apparently she had a warrant out of Jackson, and they grabbed her first. I just looked at her case, and she had a probation violation, and she just got sentenced to 240 days in jail on that probation violation. So we would ask that a bond be put back in on this case so she can get credit.
All right, so I'm going to set bond in the amount of 500 cash. And then I'm going to set a pretrial out. How far you want a pretrial?
Doesn't matter to me, Your Honor. I mean, she's going to be in.
She's not going anywhere. How about October 23rd at 8:30?
That works for me.
And then I will make a note that, I don't know if we do a writ or Miss Adams, do you usually do that via email with the local jails?
I can try, Judge. I thought prosecutors did that, but I can try it.
Okay, I wasn't sure. So Mr. Sneed, can we get a writ for a Zoom appearance?
Yes, Your Honor.
Okay, so very good. All right, that takes care of Mahoney. All right, and Mr. Glazier, back with Mr. Smith.
Yes, Your Honor. Your
How
Honor,
would you
he's
like
gonna
to
plead
proceed?
guilty, if I could, Your Honor, he's gonna plead guilty to counts 1, 2, and 3. With the understanding that 4, 5, and 6 would be dismissed. I don't remember if there's a habitual on here.
No, there isn't a habitual.
Okay, and Mr. Sneed, he's done the guidelines. I don't know whether they're right or not, but he thinks they're 51 to 85, and he said he would agree to the low end of the guidelines as a sentence. I haven't been able to confirm what the low end is, but it's probably close. Isaac probably's got a good idea as we.
So there's a killabrew to whatever the low end of the guidelines are, Mr. Sneed.
If I could just have one moment to bring up the plea form.
Yeah, I don't have that.
Yeah, I don't have a plea form.
I emailed it yesterday, John.
Okay, it didn't make it to my file yet. That's the notes I had from July 1st.
All right, Mr. Awuda-Coker and Miss Underwood. Oh, I lost Miss Underwood. Okay.
Yeah, that is the agreement, so I'm prepared to proceed if Mr.
So
Glazier.
killabrew to low end of the guidelines. All right. Okay. So, Mr. Smith, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you put your hand down? Can you state your full name for the record, please?
Jason Lynn Smith II.
All right, so Mr. Smith, you have heard your statement of, or heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, child sexually abusive material, aggravated possession, count 2, child sexually abusive material, aggravated possession, and count 3, child sexually abusive material, aggravated possession? Each one carries a maximum penalty of up to 10 years in prison and or a $50,000 fine. So is it your intention to plead guilty to each of those counts?
Yes, Your Honor.
Now, they don't stack, so the sentence would be concurrent. It would run together, and you understand there's a killabrew agreement to the low end of the guidelines between the prosecutor and your attorney.
Yes.
And you also understand, I don't know because I don't have a prior habitual. So, Mr. Sneed, does he have a prior conviction that would require sex? Okay. So, Mr. Smith, you don't have a prior conviction for any criminal sexual conduct offense, is that correct?
Yes.
All right, so you don't have one, right?
I don't. Yeah.
Okay, so then this would not require registration as a sex offender, is that correct, Mr. Sneed and Mr. Glazier?
I'm not, I can't say one way or the other, Your Honor. I don't know.
Well, I'm reading the felony information. It says it's a tier 1 offense under the Sex Offender Registration Act. So it's tier 1. So does that require registration then?
Yes, it does.
Okay, so it does. And do we know if it's like 25 years? Is it 10 years? What is the registration under tier 1?
If I could have one moment, Your Honor.
Yep, I mean, so it will require.
Uh, 15 years, Your Honor.
All right, so Mr. Smith, do you understand this will require you to register under the Michigan Sex Offender Registration Act for a period of 15 years?
Yes, Your Honor.
If you had a prior offense, it would have been for life, but this is, okay, so you understand that?
Yes, Your Honor.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Glazier?
That's correct, Your Honor.
And is that correct, Mr. Sneed?
Yes, Your Honor.
And Mr. Smith, as far as you're aware, is that correct?
Yes.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense. I'm sorry, you have the right to have the court order any witnesses you have for you. What, Mr. Glazier?
I should have muted. Hold on.
Oh, okay. I'm going to do it again. So you have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Mr. Smith, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Smith?
Yes, Your Honor.
Do you understand that any appeal from the conviction sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, so Mr. Smith, how do you wish to plead to the charge on count one that on or about June 20th of 2024, so Mr. Sneed, the city, township, or village is unknown?
It is the city of Adrian, Your Honor. I'm not
All right.
sure why that's not.
Okay.
But
Okay, so on June 20th of 2024 in the city of Adrian in the county of Lenawee, that you did commit the offense listed under count one, child sexually abusive material, aggravated possession, guilty or not guilty?
Guilty.
And under count two, child sexually abusive material, aggravated possession, guilty or not guilty?
Guilty.
And under count three, child sexually abusive material, aggravated possession, guilty or not guilty?
Guilty.
All right, so has anyone made any threats or promises to you to induce you to plead guilty to these charges other than what was placed on the record?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier
No, Your Honor.
and Mr. Sneed.
no, Your Honor.
Has your attorney promised you any particular sentence or estimate what your sentence will be other than it would be, they agreed to the low end of the guidelines? Anything else than that?
No, Your Honor.
Is it your own choice to plead guilty?
Yes.
All right, so Mr. Smith, on June 20th of 2024, all right, so Mr. Glazier and Mr. Sneed, if someone can give me a little bit of information. So Mr. Smith, were you a resident of Lenawee County?
Yeah,
Or
I
you're
was at the Adrian Inn.
Say it again for me.
I was living at the Adrian Inn. It's the old travel lodge.
Okay, so you were living in the city of Adrian, is that correct?
Yes.
And you would agree that's located in the county of Lenawee?
Yes.
All right, now the sexually abusive material you possessed, was that on a laptop or your phone?
No, it was on an old phone that I didn't even have. So
So
I don't know.
Mr. Glazier or Mr. Sneed, you want to help me with the factual basis on this one?
Your Honor, I believe on that phone, there was child, minors in sexual poses and stuff that would have been met the definition of sexually abusive material.
Mr. Smith, was that phone with you?
The phone in question?
Yes.
Yeah, I had a red one that was broken, that was getting fixed that they took. But the original device that the police officers were talking about had been gone for months and destroyed.
You know, if I could
Okay,
address the court.
Thank you.
So it's the National Center for Missing and Exploited Children received a notification from Google that a certain Google account was used to participate in the saving, sharing, or uploading of child sexually abusive material. And that was observed by Google back in March of 2024. So the videos, photos were associated with this Google account. So I think it's irrespective of whether there's an actual phone that has the digital images on it.
All right, and Mr. Smith, you would agree that there was a phone that you possessed that had over 100 images of child sexually abusive material?
Yes.
Okay. Mr. Glazier and Mr. Sneed, anything further?
No, Your Honor.
And you knew they were on there, correct, Mr. Smith?
Yes.
Okay. Has court complied with MCR 6.302 B, C, and D? What is the aggravated possession because there were over 100 images, Mr. Sneed?
For count one, it is over 100 images. Count two, involving a prepubescent child, and count three is material involving a video.
Okay, so Mr. Smith, you will agree that there were over 100 images of child sexually abusive material, and you would agree that there was at least one image of a prepubescent child, is that correct?
Yes, Your Honor.
And that there was at least one video?
Yes.
All right. Has court complied with MCR 6.302 B, C, and D? Mr. Glazier?
Yes, Your Honor.
And Mr. Sneed?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of any of them. There is a Killebrew agreement that was struck between the prosecutor's office and the defense counsel to sentencing to the low end of the guidelines, which have my staff have not run yet. So I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Smith, somebody from our Michigan Department of Corrections is coming to the jail. They'll meet with you, be truthful with them about your background, the events that occurred. They'll prepare a report. We will provide that report to both the prosecutor and Mr. Glazier, and Mr. Glazier will meet with you in advance of sentencing to review that with you. And Mr. Glazier, you're available for sentencing on September 27th at 8:15?
Yes, Your Honor.
And Mr. Smith, do you wish to appear in person or via Zoom? That choice is entirely up to you.
Up here in person.
In person? All right, so I will set that in person and we will see you back on that day. Thank you.
Thank you.
Thank you, and that's all I have with you this morning.
Okay, thank you. All right. I know Mr. Dagger-Margosian probably went down to, hold on, Mr. Murphy, I see you. Hold on. Let me get through. Mr. Murphy, what else do you have?
I'm covering for Mr. Dagger-Margosian.
Oh, I'm sorry. I did not know that. All right. So I have Madison Steinbuttle.
Yes, Your Honor.
All right, hold on. Let me let her in. I didn't know that, or I would have brought her in sooner. All right, this is in the matter of the people of the state of Michigan versus Madison Steinbuttle, file number 24-21814FH. I have Allison Arnold appearing on behalf of the people. And for today's purpose, I have Matthew Murphy appearing for court appointed counsel Michael Dagger-Margosian. This is the date and time set for pretrial. So, Mr. Murphy, how would you like to proceed on behalf of Ms. Steinbuttle?
Your Honor, Mr. Dagger-Margosian asked, he wants to set up a COBS conference with Your Honor and with Ms. Arnold I believe, so he was asking if I could ask to adjourn this for maybe 4 to 6 weeks, and then he'll arrange that with the court at a later time later today.
All right, my next available pretrial is September 25 at 8:30 in the morning.
That should work, Your Honor.
Judge, I'm in the, well, yeah, that'll work. I'm in the middle of a murder trial, but I think
How about October 2nd at 8:30 in the morning?
That should be fine too.
So,
yeah, I think that should be good.
okay, so. All right, so I'll set this out to October 2nd at 8:30 in the morning, and Mr. Murphy, your office will prepare the stip in order to adjourn.
Yes, Your Honor.
Okay, all right, so Ms. Steinweddle, we will see you back on that day. Just for your information, this is on YouTube, and so you can watch it at your leisure in case you can't leave work or whatever. You can do that on my YouTube too.
We appreciate that.
Okay.
This is part of the healing process.
I understand, but I understand we have so many cases on Wednesday, and I always feel bad when people sit here.
For my wife.
Okay, all right. So, all right, so we'll see you back, Ms. Steinwell, thank you. And Mr. Murphy, I have,
Andrew Sprague at the jail.
yeah,
right?
want to call it jail.
Well, that was the only two that Mr. Degamargosian informed me of. I don't know if
Judge, the only thing with Mr. Sprague, just so Mr. Murphy knows, Mr. Degamargosian was going to read the plea agreement into the record, get permission from read the plea offer into the record, get permission to sign it from Mr. Sprague, and then it's a plea agreement. But until that, then it's not an agreement.
Okay, we'll do that.
Okay, I didn't know if Mr. Murphy knew. I know people get busy and communication gets to be an issue on Wednesday morning, so.
Yeah, Mr. Degamargosian emailed me. I need to sign it for him though and send it over to the court. But he didn't say anything about that, I guess, but okay.
Okay, so,
right, Mr. Murphy, if you tell me it's signed, once it's signed and we confirm that and you put on the record that you will file a copy, a signed copy, I will email an unsigned copy to the court.
Okay.
So, I have no one answering at the jail. Mr. Bailey's here, and we're just waiting for Rhonda Underwood. She's probably next door at the next court. Jose Lerma is not in my courtroom. I don't see him. So Mr. Awuda Coker, I don't have him yet. Rhonda has Shannon Heatherly. Miss Heatherly was here. Okay, so Christopher Spalding is not here, but he's always here. So we're gonna take like a 2-minute recess or 3-minute maybe, and I'll be right back. I don't know.
I think I'm right. Right.
There must have been data sent on that. Sure, she's a judge. Yeah, motion.
All rise.
You can sit. All right, I got a jail Zoom. I have someone from the jail. What's your name, please?
Andrew Sprague.
All right, Mr. Sprague, hold on, let me grab your file. Okay, this is in the matter of the people of the state of Michigan versus Andrew Sprague, file number 24-21866FH. I have Allison Arnold appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. Sprague. All right,
Your Honor,
Mr.
could I have
Sprague was, hold on.
Break out with Mr. Sprague.
There is a July 10th pretrial assessment that was performed by Darren Coast. States Mr. Sprague has been in jail since June 13th on an $11,000 bond. He also has a district court probation show cause pending. This was done back in July. Just places him at a 3 on the Ohio risk assessment system. So, all right, you need a breakout room?
Yes, Your Honor, please.
All right, so Mr. Sprague, I am going to pop you and Mr. Murphy into a breakout room. Go ahead and click on join. Okay, so. All right, I have a gentleman's, hi, what's your name, please?
Jose Lerma.
All right, hold on. Mr. Lerma, let me change your screen name. And
I apologize too. When I got released, they said that my court date was on the 20th, so that's why I wasn't.
okay, it'll be on your paperwork. So I'm waiting for Miss Underwood to come back. She's in front of Judge Olsaver.
Okay.
So let me let her know that I have you. And what's your name?
My Jose.
No, I know yours, Jose. Okay.
Oh, sorry.
Nope, I got you. No, you're good. So she's next door, so I'm gonna pop you in the waiting room and Miss Underwood will be back with us in a minute, all right? Okay, you're set for 11. right, Mr. Murphy, close that room. All right, we are back on the record with Mr. Sprague. So, Mr. Murphy, how would you like to proceed?
Your Honor, Mr. Sprague wants to accept the offer. I'm going to sign the plea agreement. What we have, the plea agreement from Ms. Arnold. It was for Mr. Sprague, for the defendant, to plead no contest to count one, accosting a minor for immoral purposes of 750.145A, dismiss counts 2 and 3, and dismiss the habituals. There's an agreement for sentencing to be 1 year in jail, followed by probation. And Mr. Sprague understands this conviction will result in registration under SORA. So again, he does wish to accept that. I am signing this for him and sending it over to Ms. Want me to send it to you, Ms. Arnold, or to the court?
If you could email it to me in the court, we'll make sure the signed copy gets filed. And I sent a copy of the agreement to Ms. Adams if she wants to forward it to you, Judge, but.
All right, so he's going to plead no contest to count 1, accosting children for immoral.
Right. Sorry, that's right.
For immoral purposes, which carries a maximum penalty of up to 4 years in prison and or a $4,000 fine. And it does require Mr. Sprague, aren't you already on the sex offender registry?
No, I've served 25 years and was given a release.
Okay. So, is it tier 2? Is that 10?
Judge, it's a tier 2, but because he has a prior tier 2 offense, this makes it a tier 3 offense, and it also resurrects his prior registry requirements, so he'll be required to register for life.
Okay, so Mr. Sprague, do you understand with this plea you'll be required to register as a sex offender for life?
Yes.
Okay, and there's the COPS agreement to 1 year in jail. Is that correct, Ms. Arnold?
It is, Your Honor. Followed by a term of probation.
Okay. All right. So do you understand all of that, Mr. Sprague?
Yes, ma'am.
Write this down. And it's a no contest. Yes. Okay. All right. So is there anything else we need to place on the record, Miss Arnold or Mr. Murphy?
No, thank you, Your Honor.
No.
All right, Mr. Sprague, you want to raise your right hand for me. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, Mr. Sprague, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest to count 1, children accosting for immoral purposes, which carries a maximum penalty of up to 4 years in prison and or a $4,000 fine? So is it your intention to plead no contest?
Yes, ma'am.
All right, are you satisfied with your attorneys? Because you had Mr. Dagger-Margosian, I think, and Mr. Murphy. Are you satisfied with both your attorneys and the advice that they have given you?
Yes, ma'am.
And other than the 1 year in the Lenawee County Jail and a term of probation, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court in terms of length of probation or fines and costs. Is that a correct recitation, Miss Arnold?
Yes, Your Honor.
And Mr. Murphy?
As far as I know, yes, Your Honor, that's correct.
All right, and Mr. Sprague, is that correct as far as you're aware?
Yes, ma'am.
All right, so Mr. Sprague, if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. I'm sorry. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Sprague?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right, and Mr. Sprague, the plea is a no contest plea. So your options to my next question would be no contest or not guilty if you wanted to go to trial. Do you understand?
Yes, ma'am.
All right, so Mr. Sprague, how do you wish to plead to the charge that on or about May 19th of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense listed under count 1, children accosting for immoral purposes?
No contest.
All right. Has anyone made any threat or promises to you to induce you to plead no contest to this charge other than what was placed on the record?
No, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest?
No, Your Honor.
No, Your Honor.
All right. Okay. Mr. Sprague, other than what was placed on the record, has your attorney promised you any particular sentence or estimated what your sentence will be? Other than that Cobb's or the Killebrew 1 year in jail?
No, ma'am.
Okay. So, Ms. Arnold, will you be placing the factual basis on the record?
I will, Your Honor. Just so the court knows, Mr. Dagger-Margosian and I discussed it. The basis for the no contest plea is potential civil liability.
All right, thank you.
According to Adrian Police Department report number 5530 of 2024, on May 19th, 2024, the victim in this matter, LP, who was 12 years old at the time, was at Dunlap Park. The defendant approached her, sat next to her, and asked her, have you ever been touched? Do you want to be touched? Do you want to touch my private part? Do you want to eat my thing? And he offered to have sexual intercourse with her. Given her age is 12 years old, he intended to induce or force her to commit an immoral act, an act of sexual intercourse, or other act of depravity or delinquency, establishing a factual basis for the charged offense.
Was there any touching or just the proposition?
Just the propositions, Your Honor.
Okay. Mr. Murphy, wish to add anything?
No, that's accurate from what Mr. Dagger-Margosian relayed to myself, Your Honor.
All right. So based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on May 19th of 2024 in the city of Adrian at a local park, the defendant did commit the offense of children accosting for immoral purposes by engaging in conversation with a minor at the age of 12, trying to induce her to commit an immoral act or engage in an act of sexual intercourse or an act of gross indecency or other depravity or delinquency, and did encourage the minor child age 12 to engage in one of those acts. And therefore, the court accepts the no contest plea. Anything else on that, Ms. Arnold?
No, thank you, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D? Ms. Arnold?
Yes, Your Honor.
And Mr. Murphy?
Yes, Your Honor.
Accept the plea that has been given knowing or understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Other than the Killebrew agreement, this court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. We will set sentencing for September 27 at 8:30 in the morning. Mr. Sprague, do you wish to appear in person or via Zoom?
Yeah, via Zoom's fine.
All right, we will set that via Zoom. Mr. Sprague, someone from the Michigan Department of Corrections will come over to the jail to meet with you to prepare a pre-sentence report. when you meet with them, be truthful about your background. Obviously, you pled no contest, so you do not need to make a statement regarding the allegations against you. Just be truthful with them about your background, and they'll prepare the report. We will provide a copy to Mr. Dagger Margosian, who will review that with you before the day of sentencing, and we'll see you back via Zoom on September 27th at 8:30 in the morning. Thank you, Mr. Sprague.
Thank you.
Thank you, Mr. Sprague. You have a good day.
Thanks, Judge.
Okay, so let's see what I got. So it looks like that one's done. I'm gonna go through my docket really quick. So I have Mr. Bailey here waiting on Miss Underwood. Mr. Jones was taken care of. I have Jose Lerma present via Zoom. He's waiting for Miss Underwood. And then I have Shannon Heatherly waiting for Miss Underwood. And then I think, Mr. Murphy, I think you
I
are
think
all
that's
set.
Yes, Your Honor, I'm going to log out now. If I'm needed, I'll log back in if I need to cover anything more. So
Okay, thank you.
thank you, Your Honor. Have a good day, everybody.
Thank you. So we are just waiting for Miss Underwood. She is next door in front of Judge Olsaver. So as soon as she is done down there, she will come back here, and then we will finish up the rest of our cases. All right.
Your Honor, what is left on the docket? I've been checking them off as we go.
All right, so I have a probation violation at 8 o'clock. I have an AG case, which is Mr. Lerma. I have Shannon Heatherly, which is a probation violation hearing. I don't know if that involves you or not. I have a AG case on Spalding, and then a PPO case at 10 o'clock on Hudaker versus Conway. Probation pretrial at 10:30 on Pedro Hernandez. And then I have a motion hearing at 11 o'clock on Shane Raymer, but I believe Miss Wagner is here on that.
Yeah.
Okay.
Okay, I think I'm here on Mr. Hernandez. So thank you. Your Honor. I appreciate it.
Thank you. Yep.
Thank you.
Check.
I think her Stanley sisters.
Okay, all right, just to let you know that. All right. All right. Yeah.
All rise.
So, Miss Underwood, if I could have you approach.
Thank you.
Mr. Bailey is in the same. He owes restitution. You probably got email, but take my copy. Okay. You check them real quick so I can get mine.
Have you done anything with Lamb?
No, he's right here. He's waiting. He's in my Zoom.
Oh, Mr. Lamb is?
Yes, right. He was late by like 2 hours. But I wasn't done anyway, so it didn't matter.
Mr. Bailey? Great, how are you?
Mr. Lerma, I just wanted you to know it'd just be a minute, okay?
Yes, ma'am. It's okay. I'm
right.
waiting.
Okay, she's here. She's talking to somebody, and then we'll take you, and I'll bring you back in just a minute.
All right.
Ms. McGrain, I just forwarded an email from Attorney Keck regarding Norton versus Lenawee stamping.
Yes, Judge, I was copied on that. We're all good.
Is everything dismissed? Is the case closed now?
That case has long been closed. Phyllis is just trying to make sure that everything's wrapped up.
Okay, good. Are you ready? I'm Mr. Bailey.
Yes.
All right, thank you. So, can I have my paperwork?
Yes, you can.
Mr. Bailey, come on up with Miss Underwood.
Your Honor, in talking to Mr. Bailey has resolved the pertinent issues in Detroit, Your Honor. But he has not resolved them in Troy. So if I could ask consideration from the court and the probation department, my client is willing to plead guilty.
So why don't I do this? So Mr. Bailey, thank you for your patience this morning. Our Wednesday docket's very busy and Miss Underwood is in great demand. So in the matter of the people of the state of Michigan versus Darius Lamar Bailey, file number 20-20067FH. So Mr. Bailey, you've got a case outstanding. So what I'm going to do is I'm going to set it for another pretrial. Okay. Are you working?
Yes, ma'am.
Okay. You work full time?
No, I'm not working full time.
Okay. Do you have children?
Yes, ma'am. 4 children.
4 children? Okay. And you need to get a full-time job and I need to have payments made on this while we're waiting for the next pretrial, okay?
Okay.
Okay. And how many hours a week do you work?
About 20 hours.
Okay. And how much do you make an hour?
14.
Okay. All right. See if you can pick up a second job or something. And I would like you to pay at least I mean, the restitution will stay with you whether you remain on probation or not, but I'd like to see about $150 a month paid on this until we come back. All right, you paid 100 today, right?
Yes.
Okay, so I'm gonna set this out, Ms. Underwood, to September 25 at 8:30 in the morning. And do you want to zoom in for that?
Yes.
Okay, do you have my Zoom info?
No, ma'am.
All right, Ms. Adams, I'm gonna need a notice of hearing for September 25 at 8:30 in the morning. And let's do 8 a.m., Ms. Underwood. That way it's before your docket. And then, so September 25 at 8 a.m. along with the Zoom notice for him, Ms. Adams. Could I get that? Ms. Adams, are you back there?
I'm sorry. Yes, Judge, can you hear me?
Yep. Did you hear me?
I did. I don't know what's going on with my microphone.
Okay. So September 25 at 8 a.m. along with Zoom instructions for Mr. Bailey. So we'll get you a notice of hearing and the Zoom instructions. Just have a seat on the bench behind you. And then we will see you back, okay? Right here, right behind, like right behind you. Yep. That way, Miss Adams doesn't wonder room. Okay, so that takes care of Mr. Bailey. I have Mr. Lerma.
Do we have Mr. Owutu-Coker?
Yep, Mr. Owutu-Coker has been patiently waiting all morning with us.
Hello.
Okay, so we are on the record in the matter, the people of the state of Michigan versus Jose Angelo Lerma II, file number 24-21906 FH. I have Rhonda Underwood appearing on behalf of Mr. Lerma, and I have Mr. Owutu-Coker appearing on behalf of the Attorney General's office. This was an arraignment at 8:15 this morning. Mr. Lerma is present via Zoom. Ms. Underwood is in person, and Mr. Owutu-Coker is via Zoom. Ms. Underwood, how would you like to proceed today?
We would waive the reading of the information, Your Honor, acknowledge its receipt and the receipt of the witness list and request for discovery. We would also, Your Honor, ask the court to enter a not guilty plea on Mr. Lerma's behalf and set this matter for pretrial. I think things bode very well since Mr. Lerma is out at this point, Your Honor. He paid a $2,000 bond to get out, and he is to be working, and hopefully we can demonstrate some payments by the time of a pretrial.
Okay, so Mr. Lerma has 2 counts of failure to pay. These are, let me see, file number 2017. So it's an occurring case. So there is a monthly child support order. And what is the arrearage, Mr. Owutu-Coker?
Your Honor, it's currently $22,126. And also people would request if or inquire if Mr. Lerma would agree to assign his bond money that he posted to his underlying support case.
So Mr. Lerma must have posted through a bonding agency, didn't he?
I don't
No,
think
I
so.
went through the court.
All right, so Mr. Lerma, I would like to apply the 2,000 to your arrearage.
Yeah, you can put that towards my child support. That's completely fine.
Okay, so we'll apply his bond to his arrearage. All right, Mr. Lerma, are you working yet? Did you find a job yet?
That's where I'm at right now. I'm working right now. I'm in Marine City. I'm doing a grocery store. We're just on a break right now.
All right, so Mr. Lerma, here's the deal. You have a monthly amount of child support. Do you know what that is? Do you know how much it is?
It's a little over 200. I don't know the exact amount.
Okay, so Mr. Lerma, for you to stay out and for us to be successful on this, you need to pay your monthly amount. Do you know that, Mr. Owutu-Coker? You were going to?
Yeah. Yes, Your Honor. It's currently $542.
So you're ordered to pay $542 a month in child support. So you need to make that payment, but you need to pay on your arrearage. So you know, I know you're working long hours, you're gonna have to pay a lot of money. So you need to
Right.
pay the 542, and if you could pay at least 150, 200 towards the arrearage every month, that would be great.
Yes, ma'am. I'm working on it, and I'm gonna do a appeal to file so I can try to get it lower because I'm not making I'm only making $15 an hour right now.
All right, well, you need to file that in front of the court. So how
Okay.
far out do you want a pre-trial?
I think probably October, Your Honor.
All right, so Mr. Lerma, keep making those payments. We'll see you back for another pre-trial on October 30th at 8:30 in the morning, October 30 at 8:30 in the morning. You can zoom in again.
I didn't hear that date.
October 30th, the
Okay,
day
thank
before
you.
Halloween at 8:30 in the morning. So
Okay.
you can zoom back in on that day, okay?
All right, thank you so much.
But if you aren't making payments and doing what you're supposed to do, I'm gonna move that date up, all right?
I'll be making them, ma'am.
Okay, all right. Anything else,
Thank you.
Mr. Awuda-Coker?
Does the court need our office to submit a bond order?
Yes.
Okay, nothing further.
All
Your Honor.
right. All right, perfect. Anything else, Ms. Underwood?
Nothing else, Your Honor.
All right, we are all set then. So you're all set, Mr. Lerma. Thank you.
Thank you.
All right, so Ms. Underwood, I think we had one more with Mr. Awuda-Coker. I thought maybe, hold on. Spalding, and I wanted to talk about that one. Let me call it first. All right, this is in the matter of the people of the state of Michigan versus Christopher Spalding, file number 23-21286FH. Mr. Awuda-Coker is gone already. He like disconnected. But this was set for pre-trial today, and Mr. Spalding always appears.
Your Honor, I can solve all this in 2 seconds.
Good.
Very much to your satisfaction.
Thank you.
Mr. Spalding called me a couple weeks ago and has paid off his entire arrearage.
Shut up.
I'm not shutting up, Your Honor. And so I talked to Ms. Brenner, of course, and there is supposed to be a noli pros. It's probably sitting over in the clerk's office right now, but it is somewhere. But Mr. Spalding's case is being.
Sarah, if you need to come around, come on. You need to approach? Okay. Well, Miss Underwood, that's amazing. I always tell people they can do it and they don't believe me. So Mr. Spalding, we've adjourned this out quite a bit to allow him to continue
Not
making
only that, Your
payments.
Honor, but he received his disability and that's how he paid it off.
Oh,
But he has set up payments, so they are being taken right out of the account.
All right. Shannon Heatherly.
Hello.
Hello. Thank you. You have Miss Heatherly too.
Yes.
All right. So
I don't believe I've been appointed yet.
Oh, all right, Miss Heatherly, thank you for your patience this morning. This is in the matter of the people of the state of Michigan versus Shannon Marie Heatherly. We have two files, 23-21248 FH and 3 files, 23-21249 FH and 23-21250 FH. This is the date and time set for a show cause. Ms. Teskey is wandering around here somewhere. I just saw her, but she hasn't joined in. All right, so Ms. Heatherly, we are here on an allegation that you have violated the terms of your probation. It was a technical violation at the time it was filed, but it is now more likely than not a non-technical violation. So the allegation is on May 25 of 23, you were ordered to report as often as required. We were then ordered on April 19th of 24 to report immediately after being discharged from Dawn Farms. On July 22nd, Monroe agent Christine Lindsay was notified that she left treatment without successful completion on June 5, and if failed to report any time thereafter. Ms. Teskey is now with Mr. Stevenson. So Ms. Heatherly, you're on file number 23-21248 FH. If you plead guilty or found guilty of this probation violation, you could be facing up to 5 years in prison. On file number 23-21249 FH, you're facing up to 1 year in jail on the aggravated assault. And then on 23-21250 FH, you are on probation for uttering and publishing, which can carry up to 14 years in prison. So Ms. Heatherly, you did log in today. So I do appreciate that. Ms. Heatherly, you do have a right to have a court-appointed attorney. Do you wish to have an attorney appointed to represent you?
Yes, please, Your Honor.
All right, so Ms. Heatherly, we are running out of time today, and I do apologize for that. Ms. Underwood, are you available at 1:30 today?
I can be, Your Honor.
Ms. Heatherly, can you Zoom back in at 1:30 today?
Of course.
All right, so Ms. Heatherly, Zoom back in at 1:30 today, and then Ms. Underwood will be here, and I'll give you guys an opportunity to speak, okay?
Okay, thank you.
All right, we'll see you back at 1:30. All right,
Thank you, Your Honor.
Ms. Underwood, thank you. Okay, so now we are on Mr. Raymer. Hold on, Ms. Underwood. I never even got to Cody Getch, so I'll set him for 132. So. Okay, so Ms. Underwood, let's, in the matter of Pedro Hernandez in jail, or is he out?
In jail.
Hernandez. Miss Adams, didn't Mr. Hernandez bond out?
Don't see him on the jail sheet. I can give him a call.
Okay. So we're going to skip over to in the matter of the people of the state of Michigan versus Shane Leroy Raymer, file number 23-21665 FH. I have Rhonda Underwood appearing on behalf of Mr. Raymer, and I have Amanda Wagner appearing on behalf of the people. So this is the date and time scheduled for a motion to quash the felony information and a motion to dismiss. Ms. Underwood, you may proceed. You can sit down, Mr. Raymer.
Thank you, Your Honor. Your Honor, Rhonda Underwood for Mr. Raymer this morning. My client, Shane Leroy Raymer, was charged, Your Honor, on October 3rd with police officer assaulting, resisting and obstructing, causing injury, and 2 counts of police officer assaulting, resisting, and obstructing, and 1 count of disorderly conduct. On December 20th, a preliminary examination was held, and the defendant was bound over as charged. The prosecutor at preliminary examination, we believe, failed to establish the following elements. A defendant has the right to resist an unlawful arrest, Your Honor, via People v. Moreno. In the case of Bard, the defendant is arrested or detained at the moment when he is being handcuffed. This arrest was done without a warrant. A warrantless arrest violates the 4th Amendment if there is no recognized exception. We don't believe any exceptions apply here, Your Honor. The closest exception that people have is a misdemeanor committed in their presence. However, the defendant's conduct before he's taken into custody doesn't rise to the level of disorderly person. The defendant relies on People v. Gagnon, which states disorderly conduct, disturbing the peace provision, requires a finding that an accused, while intoxicated, directly endangered the safety of another person or personal property. In this, defendant also relies on People v. Murwadzaki, where people caught under very similar circumstances asked for identification in its door prior to arrest. What happened in this case, Your Honor, is the police responded to a call of someone in the street. They came, they saw Mr. Raymer. Mr. Raymer was in front of his house. He was having some trouble with his bike. And the officer asked Mr. Raymer, then asked, or I don't, the officer thought he asked him to fix his bike. I think Mr. Raymer meant trying to fix his bike.
He asked me what I was.
All right, we're not testifying, so you can whisper in her ear, but you can't.
Okay. At any rate, Your Honor, at that time, it's our position that Mr. Raymer had not committed a crime. He had not committed a crime. If he threw the bike in frustration, he threw the bike in frustration. It was his bike. Mr. Raymer.
I'm just trying to help.
But it's our position that a crime up to that point had not taken place. At that point, the officer tried to detain Mr. Raymer and asked for his identification. Mr. Raymer believed he was within his rights not to provide that, Your Honor, and just wanted to go back to his house. He was not approaching the officer. He was going back to his house. He was not in any way trying to interact with the officer. At that point, the officer tried to detain Mr. Raymer and put him in handcuffs, and that is when I think what is perceived as resisting took place, Your Honor. But it took place with no prior crime that the officer observed.
Okay. All right. Miss Wagner.
Your Honor, so that I don't waste any of your time, did you have an opportunity to review the response that I filed?
We did not receive one.
Oh, okay. I sent it yesterday morning.
If you send it, it's not filed. It has to be filed.
We did file it.
Nope. I just got it in my hand.
Okay. Well, that's good to know.
Yesterday, I wasn't in the office. I was at a conference, so.
Okay.
Neither was I.
Did you receive it?
Yesterday morning. Okay. So I got it this morning like that.
Okay.
I know you're out of the office.
Go ahead, Ms. Wagner.
So Your Honor, Ms. Underwood's recitation of the facts of this case and what was established at the preliminary exam just completely belied the evidence that was presented at the exam. And it leaves a lot of facts out. So when Sergeant Adams responded that day, that was the second call that dispatch had received from concerned citizens who were calling specifically about this subject, who was later identified as Shane Raymer. He wasn't just someone in the street. The calls that came in indicated that there was someone in the street who was screaming, cursing, throwing a bike, kicking a bike, you know, being a disorderly person in the street. When Sergeant Adams arrived, a child immediately pointed out Mr. Raymer. Sergeant Adams was in his patrol car. I don't know for exactly how long, but long enough to observe Mr. Raymer screaming, shouting obscenities, kicking his bike, throwing his bike. Of course, the officer didn't know at that time that it was Mr. Raymer's bike, but nonetheless, Sergeant Adams testified that he heard Mr. Raymer screaming obscenities before he ever exited his patrol car. When he did exit the patrol car, and this was established through his body camera that we played at preliminary exam and through his testimony, it shows Sergeant Adams walking up to Mr. Raymer, and I think the first thing that he asked Mr. Raymer is, "Hey, what's going on? Hey man, what's happening?" Very calm, you know, non-provoking demeanor, trying to find out what's going on. And Mr. Raymer is immediately confrontational and aggressive. And for Ms. Underwood to say—
Mr. Raymer, you need to be quiet. Thank you.
for Ms. Underwood to say that Mr. Raymer was just trying to go back in his home, I mean, that could not be further from the truth. That could not be further from what the body cam showed. And we played that at the preliminary exam. It showed him advancing several times towards Sergeant Adams. It can be heard on the body cam where Sergeant Adams says, "Hey, don't come at me." You know, Mr. Raymer is moving around a lot, advancing toward his parents, advancing back towards Sergeant Adams. All of this was established at the preliminary exam. Likewise, you know, what this comes down to is whether the arrest was lawful, not what the prosecutor charged after the fact. So the arrest is lawful as long as Sergeant Adams at that time had reasonable cause to believe either that a misdemeanor or a crime had been committed or that one was committed in his presence. And that includes misdemeanors and ordinance violations. So whether it's disorderly conduct under the statute that the prosecutor charged, whether it's disturbing the public peace, which is under the City of Adrian ordinance, whether it's public intoxication under the city ordinance, it doesn't matter what we charge later. It matters whether Sergeant Adams had reasonable suspicion that a crime was committed at that time. And all of the facts, including the 2 calls that were made within a short period of time, including the child that immediately pointed Mr. Raymer out as the problem, including Sergeant Adams' own observations of Mr. Raymer and his behavior, his aggression, his screaming obscenities that I won't repeat in this courtroom, including that Sergeant Adams could obviously see that there were people around, children, 2 older individuals who were later identified as Mr. Raymer's parents, who he also was screaming at the 2 of them, telling them not to provide police any information. Sergeant Adams attempted to calm the situation down, and it just resulted in more aggression from Mr. Raymer. Also observed, and it was very clear on the body cam, that Mr. Raymer's speech was incredibly slurred and he was unsteady on his feet. So all of that lent and supported his reasonable suspicion that a crime had been committed and was committed in his presence. The arrest was lawful, and I would ask you to deny defense's motion.
All right. Response, Ms. Underwood.
Your Honor, I think at the time, Mr. Raymer was convinced that he was being detained unlawfully. And as such, he had the right to resist that unlawful detention. Mr. Raymer, it's very hard for me to hear or to say what the officer heard before he got out of the car, because that's when body cam starts, Your Honor. And there's those few, that 30 seconds where there's no sound. So I don't know what the officer heard. But Mr. Raymer, I don't think at that point was having a problem. And I think contrary to what Ms. Wagner said, he was going back to his house. He didn't want to interact with the officer.
You need to be quiet. Okay. All right. The reason I say that is we record this so we can have a transcript of it, and we have people talking over each other. We can't hear. All right. So in this case, the defendant, through his counsel, has filed a motion to quash. I've had a chance to review the prosecutor's answer as well as their oral argument, as well as review Ms. Underwood's motion. Please, I do have a paperwork from the preliminary exam bind over, as well as information that was provided by Ms. Wagner and that Ms. Underwood would have received in her copy of the police report. During the day that day, there were multiple phone calls, at least 2, reporting an individual who was being loud and potentially disorderly. Police were dispatched. The calls notified that at 1100 South Main, a male was throwing his bike around, cursing and causing concern to nearby residents. That's the second time that day a phone call was received. Police officers were dispatched. Sergeant Adams testified that he observed a male matching the description provided, throwing a bike, kicking at the bike, and cursing. Sergeant Adams called for backup. and as Ms. Underwood correctly stated, body cam did not start till he exited the vehicle. And according to Ms. Wagner, that video would show that the police officer tried to de-escalate it, but Mr. Raymer escalated. Mr. Raymer, according to the video provided and testified or stated by Ms. Wagner, that he was slurring his words and unsteady on his feet. And he was also verbally assaultive with the police officers. So it's clear that the police officer believed, based on what he saw, that Mr. Raymer was behaving as a disorderly person who is intoxicated in a public place and who is either endangering directly the safety of another person or property or acting in the manner that causes a public disturbance. Alcohol was found on site. And I would agree with Ms. Wagner that a lawful arrest is not determined by what the prosecutor charged after the fact, but only whether officers had reasonable cause at the time of the arrest that the defendant had committed a misdemeanor offense or ordinance violation. Based on that information, Sergeant Adams would have had a reasonable articulable suspicion that the defendant had committed disorderly conduct and would have been appropriate to take him into custody. And RNOs are charged from that, and that's really up to a jury to determine. So we are set. I'm going to deny your motion to quash the bind over and dismiss. We are set for trial on September 19th at 9 a.m. September 19th at 9 a.m. Mr. Raymer, you are charged with 1 count of RNO causing injury, 2 counts of RNO not causing an injury, so a 4-year, 2 2-year felonies, and a 90-day disorderly. And understand, I don't know the facts of the case. The jury will determine your guilt or innocence. But if you are found guilty, I don't know why they were here. I don't think they were here for you. If you are found guilty, you will be remanded to custody that day. All right. Are we prepared to move to trial? I noticed that voir dire questions are due September 3rd of 24. So Ms. Underwood and Ms. Wagner, I expect you guys to prepare those and discuss them so we have a full book. Is there anything else we need for trial?
I don't believe so, Your Honor.
No, Your Honor. Thank
All
you.
right, thank you all. Ms. Underwood, moving on to your next case. You're good. Thank you.
Do I need to wait for anything? Or?
No, but Mr. Raymer, what I will tell you is you need to make an appointment with Ms. Underwood.
Your Honor, may I speak to Mr. Raymer for just a
Not right this moment. Let's get your other case called and then you can talk to him.
I'll wait patiently for you.
All right, so you can go in the hallway. So Denise Hudiker versus Ernest Conway.
But that's not my case, Your Honor.
Oh, okay, I thought you were on it. It has you on it. Okay,
That was conflicted out.
okay. Miss Adams, is Pedro Hernandez in custody?
So I haven't heard back from him, but according to the August 5th date, you set bond at 25,000, so he should be in custody. So I'll keep trying.
All right, well, we don't have time to do that. I can set that over to 1:30 and see if we get him back.
Okay.
And so what is your name? All right, so evidently there was a conflict attorney appointed, you're saying, for Ernest Conway?
I believe it was Mr. Daly. I'm not sure who his conflict attorney is.
Okay.
Judge, Mr. Hernandez is in jail.
Okay. All right. Oh, this is just, okay. All right, ma'am, are you able to come up to the podium?
Yes, ma'am.
Okay, 1:30, I'll see you back at 1:30. I'm sorry.
Are you gonna need a prosecutor for Mr. Hernandez? Because I'm not available at that time.
It's a probation violation, so no.
Okay, thank you.
Okay. All right. All right, this is in the matter of Denise Hudaker versus Ernest Conway, file number 2024-51649 PH. So, Ms. Hudaker, you have filed a motion to terminate the PPO. You stated that you love him dearly and you want to be with him. He's a very sweet man and someday you plan to marry him. I was just really mad at him on that day and you want to terminate it so that you can spend your life with him. So, Ms. Hudaker, back on, you provided a police report to me on June 7th of 24. You had contacted the police and you said that violated the PPO. Let me see here. And you said he goes in and out without permission of your house and tries to make you go into seizures and then messes with you when you're in one. And said he's going to kill your friend. Nate Deck feels threatened when Ernest comes over. And so, you know, you basically previously said that he was making threatening comments to you and your family. So, Ms. Hudaker, and you now want the PPO dismissed?
Yes, ma'am.
Okay, are you afraid of him?
No, not no more. I was in a seizure at that time when he was approaching me because he didn't know how to deal with the seizure that I was into. He was in my face and my friend kept telling him to get away from me so I can just finish my seizure and then he could talk to me. But he didn't understand how to work my seizure that I have. I have it like maybe every week or sometimes more than twice a week.
Are you Nathan?
No.
I'm her son.
That's my son Kyle.
Okay.
He's
All right.
my medical power attorney. He takes care of me.
Okay.
It's okay if I sit down.
We're done. I'm going to grant your request to terminate the PPO. Ms. Hudaker, you're all set.
All right, thank you, ma'am.
I'll terminate. Thank you. All right, Mr. Stevenson, I'll see you back at 1:30. Mindy, I'll see you back at 1:30.
Judge, I won't be here, but I'll try to grab someone else to cover that.
Okay, thank you.